Good evening.
Hey,
This is Dr.
Jono.
Milburn for Laws 11062. This is Contract B, and great to have you on board for this session. We have a number of people enrolled in the unit and many people online as we proceed this evening, so that's excellent. I will just invite you to mute microphones generally if you're not speaking or there's some noise in the background. Now, tonight we're dealing with the issue of mistake. But before we do that, just a few general comments. For those of you that have worked with me in the past, nice to see you again. For those that have not worked with me in the past, you'll know that I have a few matters that I'd like to ingrain, particularly in relation to your assessment work and some preferences in terms of the way we go about the unit. So the first thing is that by way of background, I'm a barrister in private practice. I'm also a member of a couple of tribunals, and of course I teach at this university where I've had the privilege of taking a wide range of units, and this is the first time that I've taken Contract B. So I'm relying very heavily upon some excellent material put together by predecessors, namely Dr. AJ George, who took this unit last term, and I'm effectively filling in for AJ. Those of you that have worked with AJ George will know how very good she is. And prior to that, there was Dr. Marinac, and Anthony was also very good. So you'll see a lot of the material reflects their work and their contribution, and I'll simply add to that in many ways. I've been with the university now for about 8 years, and I've taken a whole range of units. And of course, all of those are available, as this will be, through YouTube if you want to check out some other work that we've been doing. Now, because I practice in law, and I've been practicing in law continuously pretty much since I was admitted in 1984, January, and I started studying full-time in 1977, so pretty much every day has been devoted to law in one way or the other. You'll excuse me when I say that the focus of the unit is really designed to those that wish to practice in law or be involved with or engage with people that do practice in law. So many of you, I appreciate, won't actually practice as solicitors or barristers, but many of you will be involved in some way or another in legal practice. So when I teach, I try to have a fairly practical aspect to it. And I do have some philosophies of practice. One of them is this, and this is really important. Things won't always go your way. Things won't always go to plan. So you need to develop a system of remaining calm and cool in the study of law and generally in the practice of law or whatever it is that you're doing. What that means is developing a mindset. And those of you that have used The New Lawyer as a textbook will remember a quote, certainly one that I introduce at an early stage when I'm taking Introduction to Law. And that is, and it's from page 286 of the current edition. Thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. So remain calm, remain focused, and very importantly, when you're studying law, think about your ultimate objective. Part of the reason for doing that, and I'm talking really about the objective in this unit, part of the reason for doing so is that you work in reverse. And those of you that have worked with me in the past know that I have mentioned this philosophy in the past, and I want you to adopt it again this unit. For those that are new working with me, hear me out. So imagine a scenario where you've done practically everything right, but you just miss one key issue or one key matter. And you think about the cost to you physically, emotionally, and financially if you fail. Now, I'm really talking obliquely now about things that you might have done differently with the benefit of hindsight, where with the benefit of hindsight, you might have adopted some techniques to avoid easily avoidable mistakes. Here's a simple example. I receive a text from a client saying, would you please do this for me? It's a very simple task, and you know that it's important to the client, but you're overwhelmed with other work and you forget. You do 95% of the work for the day very well, but you forget this one small thing. How does that then make you feel when the client says, I'm shattered, you didn't do this thing, it was a very simple task, very important to me? It'll affect you emotionally, physically, and maybe even financially. So do try to take steps to avoid that from occurring. I mean, it's the old keys in the fridge. You know what I mean by keys in the fridge? If you've worked with me before, you'll know what that means. Somebody phones, says, can you bring something home? You put the keys in the fridge. So when you go to get in the car and the keys aren't where they should be, you go to the fridge and think, oh, okay, I must remember something. It's a very physical thing. Those of you that are old enough to have had crowns, has anyone had dental crowns? I'm old enough, I've had dental crowns. Anyway, you'll know that when you have a dental crown, you've got to be very careful the way you floss. Otherwise, you might rip the crown out while it's temporary. Do you understand what I mean? So what do you do? While you've got that temporary crown on, you take some physical steps to avoid having something bad happen. And one of the things that you might do is put the dental floss in a different place. So those of you that are working with routines will know, or something's different. Why is it different? Oh yeah, I don't want to pull out the temporary crown. So all sorts of practical little help, all practical examples about how to help. What it means is that you've got to think about what it is that you want to achieve, think about what might go wrong, and think about things that you can do to avoid the things going wrong in the first place. In the context of this unit, that means starting with what? I'll get you working on the typing, or unmute your microphone. What's the key thing that we need to start thinking about today in the context of this unit? We're looking to work backwards. Assessments, says Jessica. Yes, very good. Any other thoughts? And that's pretty much it. Exam. Yes, thank you, Jessica. So your exam preparation starts now. Maintain a folder or a document. So every time I mention something about exam, you'll know to record it in a central location. There's no point in the week preparing for the exam to realise that I said something that was an exam hint, but you've forgotten it. And you can't find it because you're now rushing. So think about where you'll put these things, because you will get exam hints. Also, Jessica's right, Nicole's right, timeline, and then you don't leave it to the last minute. Thank you, Nicole, and thank you, Jessica. So think about what you want to achieve and work backwards from there. If you do leave things to the last minute, then you may have some difficulties. Something may occur that you hadn't expected. The question then is, what do you do? You might apply for an extension of time, but if, as I intend to do, I release the assessment work for you at an early stage, then your chance of getting an extension in relation to work where you've had many, many weeks to prepare for it is likely to be refused. So think about that as you prepare for your work. Now, would I be correct in assuming that we all know how to upload our assessment work? We know how to prepare a Word document. We know how to upload it as an assessment. If you don't, please feel free to ask now or ask through Q&A. All right, so I'll work on the assumption that you know how to upload your assessment. If not, this week is the week to find out. Now, speaking of finding out and asking questions, apart from this weekly session, Mondays, every week, Please ask any questions through Q&A in Moodle. I'm sure you've all seen my note now in multiple places to say, I'm not using Facebook this term. It's something that Dr. George was using last term, but I'm not using that. So anything we do will be centred around these sessions or Moodle. If you need to email me, fine, but if it's a question in relation to the content, be prepared for a response to the effect that that's a great question, asked through Q&A. The rationale behind that is then we all get to share in the response and we can exchange ideas as well. All right, any questions then about communication? We know no Facebook, use Q&A, email if you have to, but I may refer you to Q&A anyway. All good? All right, good. So assessments. Number 1, problem assignment, 20%, 2,000 word maximum. Make sure that you cite your material using the Australian Guide to Legal Citations, 4th edition. So make sure that you have a ready reckoner on how to cite your material in accordance with the AGLC 4. Now's a good time to be honest. If you don't know something, ask, because I'll ask this question. Is there anyone that, and don't be afraid to answer, is there anyone who does not know how to use the Word program to insert footnote referencing? Anyone who doesn't know how to use it? Can anyone willing to volunteer to unmute the microphone and tell me how to use footnote referencing to insert a footnote reference using the Word program? Philip? Nicole?
Yeah, hey.
Yes, Nicole.
So you go up the top to reference and you go up to references and then it's got AB with a little 1 above it and you click that and it's insert footnote. Oh, sorry, it's next to the AB1 and you insert endnote.
Is it endnote or footnote?
It's an endnote and then it gives you a footnote that automatically attaches to it.
Footnote, okay, good. So thank you very much, Nicole. Thank you for that. And thank you for Jessica.
Sorry, getting classes mixed up.
Okay, so it's built into the Word program and in essence, it's dead easy. In the AGLC 4, you'll see some reference to how to footnote reference. That tells you some of the technical side of things, but in terms of the actual practicality, the Word program's very easy. So please have a look at some good reference material to learn by osmosis. Do you know what I mean by osmosis? By looking at it and getting the feel for it. A very simple way to provide a document that is something I would like to see for an assessment, which includes footnote referencing and other material, is to have a look at the sample document that I've put on Moodle. So it's something that I created. It provides some substantive content, but it also shows you a format that you might want to consider. It's not the best example. Students have come up with much better looking work, but it's okay. What I've prepared is it works in terms of the basic function. So, and you'll see in there the technique that at least I use for footnote referencing and referring to material generally. So the first assessment you haven't seen yet, but you will see it soon. My aim is to have it available to you by the end of this week. And when it becomes live to you, I expect that you'll read it soon and start to think about what it is that you wish to insert by way of an answer. What that means then is that when you're reading your text and other material, do so actively. So you've got to be an active reader. One of the best ways of answering legal problems is to read a case and where the judgment is written such that the facts are identified at an early stage, stop and try and answer that as if it was an actual exam question And then once you've completed that task, then go and read the judgment to see if the judge agrees with what you would have said. Do you see what I mean? So if you've got a case about contract law, let's say mistake, and you know that a particular case relates to this law of contract in relation to mistake, read the facts, do your research, nut out an answer guide to yourself, and then read what the court said. So you're really actively reading the material. And of course, when you're answering a question for real, make sure that you read the rubric, understand the rubric, and you'll have a good idea of what it is that I'm looking for. That's the first assessment. Now, the second assessment is a video presentation. Would I be correct in assuming that everyone in the unit knows how to record a video and upload it in a way that I can then view without it coming up with an error message to say, I can't view the video or something else? Typically what people do is they might use Zoom, typically because we're using Zoom through this university, and upload it to YouTube. You may have to create a channel for yourself and then provide the link to the video presentation in a Word document. So it's the Word document that you upload through Moodle. I then download that document and I find the link, click on the link, and I'm now seeing your video. Does that make sense? So please ensure that you're aware of the technology. If you don't know or understand the technology, this week is a great week to ask, and don't be afraid. So your task in the second assessment, worth 30%, is to develop a video, develop and present oral arguments and submissions. It's like in a courtroom setting. So we want you to some degree to look the part, and in the submissions you'll cover material that we're covering in this unit. And then of course we have the examination, which is an invigilated examination, meaning that it's pen and paper. 2 hours. It was 3 hours a couple of years ago, but 2 hours, and the examination date will be within the examination week, but I don't know the exact date. In fact, it hasn't been allocated yet, but when we know, we'll let you know. And Nicole says, do we need a blazer? I'm having a hard time finding one in the tropics. No, you don't need a blazer, but just present in a way that you would be happy to do as if you were appearing in court, so to speak. So, for example, tonight, whilst I normally wear a tie, I ditched it, so you don't have to wear the tie, just something that's presentable. There will be a question that you ask yourselves about the degree to which you can collaborate. Now, I mentioned we're not using Facebook this term. There is a Facebook page for the law school, so that might be an avenue that you can collaborate. And of course, you can set up your own private groups for study purposes. You will need to understand the rules in relation to what is collaboration compared with what is collusion. Collaboration is where you work together to discuss ideas, to discuss assignment work even, to consider reference material and talk generally about work. So you need to understand the line between genuine and lawful collaboration against unlawful and improper collusion. So, for example, to write something which was, present something that was written by another student would be collusion and illegal, and it's plagiarism. So you just have to understand that. And on the Moodle site, you'll see that I've provided you with access to university guides and procedures about student academic integrity. So please understand that. It's very important. Those of you that have read the Humsey Hancock case, which we refer to quite regularly in Introduction to Law, will know what I mean. But generally speaking, be honest and do not claim the work of others as your own. You need to produce original work. Having said that, you can certainly refer to the work of others, and you're expected to refer to the work of others, but it is a matter of ensuring that you identify that as their work and you reference it accordingly. If you're really struggling, another place you can look is the Student Success Team, and the email address is sat@cqu.edu.au. All right. I mentioned earlier that you need to be well prepared. And they're not just idle comments, they're really important comments, because for those of you that are relatively new to studying law, you'll know that it can be pretty stressful. Again, the new lawyer has a quote, some information. I'll read it to you. If you've done intro with me, you'll heard this before, but learning self-management skills, which is something you need to adopt at law school, is important if you are to ensure that you maintain good psychological health during and after your legal studies. You need to be on top of things and be prepared for things to go wrong in order to maintain good psychological health. For example, a study led by Catherine Lay assessed 955 students at the University of Adelaide and found that, and this is a whopping figure, 58% of law students were psychologically distressed. This was the highest level of distress recorded across all of the disciplines studied. Medical students came second at 44%. Now, the study shows that there are special issues for law students, and it emphasises the need for students to take particular care of their psychological health. Now, I have a theory. As to why law students have so much more psychological distress than other students. Does anyone have any theories as to why that might be the case? Before I proffer my opinion, to use a term that we refer to in law often, why do you think that law students have such high levels of psychological distress? Jessica's that's a good word, Jessica, perfectionist. I like that. We like to be very good, very thorough, but we don't need to aspire to be perfect. Marissa had another very good P word to continue the alliterations, pressured. It's pressure. So how do we deal with pressure? Anticipate it. You know, those of you that might have played football will know that if you can feel a tackle is coming on, you brace yourself for it, don't you? You plan for the pressure. So you know the tackle's coming. You know the impact is coming. So brace yourself for the pressure. Any other theories on why law students have such, that's a good word, Harley, expectation. Yeah, we might have too much of an expectation. So generally, there's nothing necessarily wrong with lowering your expectations a bit. That's going to be seen as counterproductive. And the Dean of the Law School will be saying, John Milburn, why are you telling them to lower their expectations? You want them to increase their expectations. Just lower. If you've got really high expectations, just keep it under control. Having said that, we want you to work hard and do well. Do try to have fun with this as best you can and enjoy the process. My theory is that law students have high levels of psychological distress, in part because we're trained to find the answer. You know, if you're doing maths or physics or chemistry or something, then you're looking for an answer. It's a discrete answer, and it is the answer. But the advantage in law is this. Don't necessarily expect to know the answer to anything, and don't necessarily expect that you must have the perfect response. Don't feel pressured to come up with the one answer that you think I will have in mind for a particular question. You'll see there that I've used Jessica's, Marissa's and Harley's words in answering that response. Tanya, excellent. There are multiple sides to any argument. And that's the great thing about law, and that's what takes the pressure off. You don't necessarily have to have the right answer. You can still get a 7 and have an answer that's completely wrong in terms of the final result as far as I'm concerned. Because the answer I come up with isn't necessarily right. The answer that any one lawyer comes up with to any given legal problem is not necessarily right. Otherwise, we wouldn't have 4-3 splits in the High Court, would we? You can't say that 4 of the judges know the law and the other 3 have got no idea. They come to a different conclusion, and they may arrive at the conclusion by different means, by different philosophies, approaches, even by referring to different statutes or case law. But that doesn't mean that they're all wrong. They can all get 7s in the High Court, as you can, even if you go about things differently. I need to put in a word of warning there. There are some basics. So if you're really just not on the right track, then you will be penalised in terms of the marks. But I want you to feel comforted by the fact that even if you are on the wrong track, you can still pass. And even if you come up with the wrong answer, so to speak, you can still get a 7. I know that's a bit vague, but Tanya's right. There are multiple sides to any argument. Jessica says it depends, and that's right. So the first step is, if you really feel the pressure, to use Marissa's word, and you're just frozen in the moment, make sure that you start to write. Get something down on paper and go from there, and then it'll start to flow. Any questions so far? All good? All right. In terms of the way you write, the way you communicate, simple is best. If you've worked with me in the past, you know that I encourage people to use short sentences. Now, that's a safety, that's a fallback position. The tendency with a lot of people is to write long, rambling sentences that seem to take forever to get where they're going. Short and sharp is a safer approach. So whatever it is that you do, communicate simply, communicate effectively. If you can string that into phrases that work together in a sentence well, using good grammar, fine. But if you've got uncertainty, keep it simple, keep it short. By this stage, I know it's only first year subject, Contract B, but you should know how to source the law. You should know how to find legislation. You should know how to find case law, and you will be expected to read those things, at least to some degree. So in other words, you must go beyond the study guides and you must go beyond the textbooks to some degree. So that means being able to access the primary sources of law, legislation and case law. Now, we can all do that, can't we? It's a good time to be honest. If you don't know how to access legislation or case law, now's a good time to say, are we all good? I'm really putting the pressure on people, aren't I? I'm saying, fess up now if you don't know how to do something. Nothing wrong with asking for help. So, of course, legislation is the largest source of law. It's the basis of our Australian legal system. But is it important, relatively speaking, in the study of contract law? On your buzzers, yes or no? Relatively speaking, is legislation important in the study of contract law? What do you think? I'm not getting any votes yet. Not as important as case law, says Michaela. Tanya says yes. Gareth and Harley say no. Any other votes? Natalie says no, mostly common law. And now we're getting a lot of no votes. Tony, Gary, Jessica, yeah, thank you. Yeah, Alfred, good one, except for consumer protection. Tanya came in with it at the same time and said ACL. Yep, so this unit, this term, I'm also taking environmental law, doing that tomorrow night. And environmental law is very much statute-based. You know, environmental law starts with treaties, international obligations, and then filters down to legislation at both the state and federal level. And from that, we have the case law. And in fact, the common law is very limited in terms of the practice of environmental law, because at common law, for example, there was no recognition of environmental law as a discipline at all. It was all about the rights of individual landholders, etc. The environment and the bigger public issue just wasn't on the radar for the common law courts. So environmental law has really been as a result of the introduction of legislation. Now, it's the opposite for contract law. We're still very much dealing with case law, apart from Alfred and Tanya correctly identifying the need to consider consumer legislation in particular. But whatever it is, make sure that you have your way of accessing legislation and case law now. All right. So what is contract B? Finally, we're talking about contract B. Well, it develops on what we learned in contract A. Yes, that's pretty obvious. But now we get to the more interesting aspects. So we all know how a contract is formed. Can anyone tell me what are the 5 matters that we need to consider in the context of deciding whether we have a contract or not? Any takers? I think there's 5. Am I correct in saying 5? Offer, number 1, yes, Harley. Acceptance, number 2, yes. Intention, number 3, thank you, Alfred. And Tanya says capacity and consideration. Yeah. And intention to be legally bound, I think, as well in there. So that's kind of with capacity. Yep. So bear in mind all of those things. When you're answering a question in contract law, and it's fairly obvious that the examiner, me, is inviting you to talk about things like mistake or misrepresentation or duress or undue influence, that does not mean that you should ignore other things. Now, some lecturers will say to you, look, answer this question, and I'm only interested in you providing me the commentary about the law of mistake, which is fine. I tend not to do that. I might ask a question that fairly obviously looks like it's about the law of mistake. But if you identify that there are some things that may also be relevant, word count permitting, I'd like you to mention it. When you read a question, you might make some assumptions, consciously or even unconsciously. You might assume certain things. And it's always a good idea in answering a legal question, certainly with me, and I think with lecturers generally, to state your assumptions. As barristers, we have to do that all the time. So if we provide an opinion and we have 95% of the information that may ultimately be relevant, but we don't have that 5%, we've got a choice. We can either ignore the 5% and say nothing, or better still, we can say, on the assumption of this and that and this other thing, here is the advice. That way, if the instructing solicitor or whoever comes back and says, look, it's not actually a contract that was formed in Queensland, it was formed in New South Wales, that will affect the rest of your advice, won't it? But if you've made an assumption that we're talking about a Queensland-based contract and you've answered the problem on that basis, that's fine, but it's better to say, I'm assuming this contract was in Queensland. Do you understand what I'm getting at? If you studied intro with me last term, you'll know exactly what I'm after. So when you read a question or anything to do with law, read actively. Think about, what am I presuming here? And if you are presuming something, pop it in. Now, you've all got legal toolkits, I assume, if you've done Introduction to Law. You should be building on those. And as you come up with something, when you're reading a case, it may be, here's a basic one. This case is in relation to a person who is over the age of 18 years. So thinking actively, you might think to yourself, oh, I wonder if the law is different or would be different if this person was 17, not 18, things of that nature. Or if this person was educated, not educated, which goes to some of those capacity issues that Tanya, Jessica and Thea talked about in response to my earlier question. So if you have some assumptions, please let us know. So last term in Contract Day, we talked about how to form contracts or what's involved in the formation of contracts. And we talked about interpretation and construction of contractual terms, still relevant but not the main focus. So here's what we're looking at where things go wrong. And that can be as a result of the things I mentioned earlier, mistake, misrepresentation, etc., but also things like unconscionable or illegal or void contracts. So, you know, somebody comes to you and says, I want you to pursue a debt. This person owes me $10,000 as a result of failing to comply with the terms of an oral contract. What are some of the assumptions that you might make before you go marching off to court to pursue that $10,000? What are some of the traps? What are the things that may influence your decision whether to sue or not, or whether you'd be successful? So any thoughts? We'll start really basically. Someone says, please pursue a debt for $10,000 unpaid under a contract. What assumptions will you make? Any thoughts?
That they would have fulfilled their side of the
promise. That's a good one. Yes. So that they have fulfilled that they're not in breach. Tanya says, is the contract written? No, let's assume it's oral for the moment. Michaela says that the parties intended to create legal relations. Yes. Anything else? That the parties had capacity to contract and the terms were certain. Yes. Very good. Anything else? What if you consensus ad idem? Thank you, Gary. What if you later found out that the contract was actually made in Iceland? Would that affect the advice that you give? Maybe. It's not so far-fetched now, is it? We buy things over the internet, don't we? So we're all dealing with international contracts regularly. Alfred says legality. Yep. We're assuming a number of things, aren't we? What if the contract was what if the debt was incurred as a result of a contract in an illegal gambling den? Would that make a difference? What if the person who owed the money now says, yes, but they made me an offer I couldn't refuse? Do you know what I mean? It was duress. So all of these things have a part to play. So what we're talking now about is some of the assumptions you need to make. So as you're reading cases, think about what it is that you've assumed to be the case. And for the purpose of the examination, if you're dealing with a contract, you might even just say something to the effect that assume that the contract was validly made between the parties who had capacity to contract and there were certain terms, to borrow some of the wording provided by Megan. Thank you, Megan. Alfred says liquidated damages in response to Tanya's question, what can possibly go wrong? All right, so when you're dealing with a contract and things do go wrong, then it may be that there are some prerequisites to consider before suing. For example, the question is, might be, has the contract been validly terminated? What are the remedies available for non-performance of a contract? And we'll talk about some of those things. Now, there are some what we call vitiating factors in a contract They're those that go to the existence of the contract, and if these factors don't exist, it will invalidate the contract. So vitiating elements might be mistake, duress, misrepresentation, undue influence, and illegality. We'll also talk about estoppel. Does anyone know what estoppel is? Estoppel? E-S-T-O-P-P-E-L. It's a uniquely legal word, but you'll see it often. And when we're doing equity and trusts, you'll see estoppel. So estoppel is essentially preventing an action from occurring. Not quite. It's not like an injunction. Reliance of a promise, says Alfred. Yeah, that's getting closer. Estoppel. And I know Marissa's going to the dictionary. Good. Any others? Any other thoughts? All right. What if you make a statement to someone else and then later go back on your word? That might be an estoppel. And an estoppel is essentially an inability to rely upon something that was said or an action that was given to somebody else as a result of a misstatement by someone else. It's not quite misrepresentation, but it's where there's something set up that causes a situation where it would be unfair on you to profit from that situation. So estoppel, have a look for it because it's important. And ultimately, what we're looking to do is determine through this unit what we can do about things, what remedies are available so that a court can do justice to an innocent party where there's been a problem with a contract. Just very quickly now, just to get you working, what are some of the remedies that come to your mind as potentially being relevant for contract law? Suing for damages, says Alfred. Yes. Any other remedies that you think of? Something goes wrong. What can we do about it? Megan and Alfred come in with injunction almost as a dead heat. Yes. Michaela, specific performance. Yes. Rectification. Very good, Jessica. What you probably need to do is develop your toolkit a bit by adding some of these remedies that are typically available or may be available. So you need to understand what we mean by injunction, specific performance, rectification, and you need to understand and appreciate the difference between common law remedies and equitable remedies. You'll see that distinction a lot. Do we all know the difference between common law and equity? It's okay if you don't, because it's not necessarily easy. And those of you that might be studying this unit, not having studied law previously, will wonder what I'm even talking about. All right, so you need to understand the difference between equitable and legal remedies, and that will have a bearing on things as well. During the course, yes, sorry.
Sorry. Usually with common law, it's based on what is law,
Yep.
while equitable is when what is fair to the other party.
That's it. That's very good. And just to confuse things even more, decisions that are based on equitable principles, decisions by a court, become part of our common law. So the common law becomes a sort of strange hybrid of that which is traditionally common law, black letter law, and equitable decisions as well. It all goes back to the old medieval days when there was a distinction between the two, and there was a merger in the late 19th century, enabling most courts and tribunals to provide equitable as well as legal remedies, but not always. And different courts have different abilities to impose orders and make decisions. So always keep in mind that jurisdictional thing. Do you know what I mean by the word jurisdiction generally? What's a way of describing jurisdiction for me? Any thoughts? What do I mean by jurisdiction? Specific areas, says Jessica. Area, says Natalie. Yeah. We think of jurisdiction perhaps geographically, but in a legal context, it can be geographic, but more often it means that authority which is conferred upon a court to deal with a certain matter in a certain instance. For example, if prosecution took a matter of an unpaid speeding fine to a tribunal, then they may have the ability to obtain an order for damages or an award, a monetary claim, but the tribunal can't send the defendant to jail, can they? Whereas magistrates do have that ability to send people to jail. So the jurisdiction means the ability of the court or the tribunal to undertake certain work in certain areas. Not all courts and tribunals can deal with all matters. If you have a divorce, then you can't go to the district court and ask for a dissolution of that marriage. Do you understand what I mean? So keep that in mind. All right. So mistake. Mistake in contract law, chapter 14 of your text and chapter 14 of your casebook. So you should have both the textbook and the casebook. All right. In week 1, we deal with the situation where parties enter into a contract based on various kinds of mistake. The types: unilateral mistake, common mistake, and mutual mistake. Does anyone work in a law firm and know what I mean by mutual wills? Mutual wills are, if you have a husband and wife, for example, typically in a second marriage, Tanya says yes. Correct me if I'm wrong in this explanation, Tanya, but husband and wife, typically, let's say second marriage, come in and say, look, we'd like the same wills, which is to allow for us to provide for both sides of the families, but we want to ensure that we don't change the wills, because if I die, I don't want him or her to go off and re-partner, and then everything gets left to, you know, his or her family, or worse still, his or her new partner's family. I want to make sure that when I die, you know, even though I might give everything to him or her, at least my family will be protected. So they're virtually contract wills. Yes, Tanya. So mutual wills is where you have essentially a contract between the two parties to enter into wills that have the same effect. Now, they're different wills, aren't they? They're different wills because you can't have, people don't sign the same will, they sign their own will. So they're different wills, but there's a mutual intent there. It's the same thing with mistake. When we're talking about mistake in the context of mutual mistake, the parties have made different mistakes. They're at cross purposes. They've both made mistakes, but they're different to the mistakes that the other has made. Common mistake means the parties have both made mistakes and it's the same mistake. It's a common mistake between the two of them. Really important that you work out your own way of remembering the difference between common and mutual, because odds are you'll be examined on that. So you need to understand the different types of mistakes, the different categories, and understand how to describe this in the context of an assessment or exam question. Now, a really good thing to do is look at the flowchart. Have you all looked at the flowchart? And I think this was prepared by Dr. Marinak originally. It's very good. It makes it really simple. So do look at the flowchart. It's on Moodle, and work your way through that. As you're reading the commentary in the textbook or cases, make sure that you follow that logic in the flowchart. And what it means is asking yourself a series of questions as you answer a problem. You know, have one or parties made a mistake? if both parties made the mistake, was it the same one? One thing is clear, the two parties have not really come to an agreement. So the question is, how does the law resolve these issues? What do we do about mistake? How do we come to the party's rescue in terms of dealing with this? So those of you that studied Introduction to Law with me in Term 2 might recall one of the questions in the take-home paper. A property owner included a deck or built a deck, and it was not council approved. So when the property was sold, assuming that the buyer thought it was approved, but it wasn't, the question is, was there a mistake? And I don't think anyone who answered that problem in Introduction to Law went there in terms of that potential argument. So just keep that sort of thing in mind. So the question is, would the courts assist? But they are reluctant to intervene on the ground of mistake generally. And the courts have generally take a view that if the parties have come to an agreement, we let them stick to that agreement, for want of a better term, and the parties have gone in with the risk that there may have been a mistake. So courts are not quick to move in that regard. Right, so the first one is unilateral mistake, which is a mistake in circumstances where one party to the contract makes the mistake, but the other party knows or ought to know that a mistake is being made. Example in the study guide, Maria offers Stephen $200 to tutor her in contract A. She says, I know you got a high distinction, so you know what you're doing. Stephen didn't get a high distinction, he got a pass, but he wants the $200 and proceeds anyway. So arguably, that's a unilateral mistake. It's a mistake because one party makes a mistake, the other party knows or ought to know that the first party made the mistake. So you might think this is a clear example, but I guess the counter argument is this. If you're looking at that, you know, it's very easy when you're studying the law of mistake to go, oh, I found it, that's a mistake, that's a unilateral mistake, that's the end of the argument, that's the end of the question. Remember at the start I said one of the good things about law is there's always a counter argument. So in that example, for those of you that were carefully listening or carefully reading the example in your study notes, if you're on the other side, what arguments might you come up with? One fundamental thing might be, well, even though Maria said, I know you got a high distinction, you obviously know what you're doing. The question then might be, Maria never confirmed, says Harley. Yes. One question might be, well, must you have received a high distinction to know what you're doing? If you've passed the subject, arguably you still know what you're doing. So is there a difference between getting a high distinction and knowing what you're doing? And Stephen could argue that there was in fact no mistake, because even though he didn't receive a high distinction, that wasn't the key element in Maria's mind. The key element in Maria's mind is whether you know what you're doing. Do you understand that subtle difference? So if you see a counter-argument when answering a question based around mistake, then it's good to introduce it, even if it's not in your client's best interest, because then at least it identifies the sort of argument that your opponent may come up with. And it shows that you're thinking very carefully and clearly and not just one-dimensionally. So Jessica says, well, was Stephen's grade fundamental? Very good. Did he try to prevent Maria from the truth of his grade, which on the facts he didn't do? He just accepted it. And, you know, the question is what's fundamental? Whether he got the high distinction or whether he knows what he's doing. The two aren't necessarily the same thing, is really the point. So thank you. So these are the sort of things that you need to consider when you're studying contract law, and you need to develop those skills, particularly in your second assessment when you're making your oral submissions. Mounting arguments, but then also anticipating, and to the degree that you can, nullifying arguments of the opponent. If you have a unilateral mistake problem, you need to know how to analyse it. How do you deal with that? So it may be that the mistake relates to one of three things, one of three categories. It might be a mistake as to the subject matter of the contract. It might be a mistake as to the identity of the other party, or it may be a mistake as to the nature of the contractual document. Have a look at your study guide. In relation to the subject matter, refer to Taylor and Johnson. And that was a mistake about whether a contract was meant to be for a price of, for property, $15,000 or $15,000 per acre. And in that case, there was a clear contract which said $15,000, but the court found that Mrs. Johnson was mistaken, and to the point where the unilateral mistake could be the subject of a remedy in her favour. If you can show that your client actually did make a mistake, is that all you need to consider, or is that the, sorry, I'll reframe this in a way that I think makes sense. If you're arguing that your client made a unilateral mistake, is it sufficient that you simply have the court accept that your client did actually make the unilateral mistake? What's the way of looking at this? I'll give you a hint. No, says Jessica. Yep. Do you know the difference between the objective test and the subjective test? Is really what I'm getting at. And I couldn't quite get there. So if you do know the difference, that's good. If you don't, please do some research, understand what we mean by objective and subjective. Was it Lord Denning said? I think it was Lord Denning said, the observer on the Clapham omnibus. But you're too old for that, so you won't know. Oh, sorry, I'm too old for that. You're too young for that. The reasonable person. Yes, Marissa. So you need to know what we mean by the objective test and the reasonable person. Right. So in that case of Taylor and Johnson, the High Court said that equitable principles would allow Mrs. Johnson to rescind or set aside the contract because, and this really comes back to Jessica's point earlier, Mr. Taylor did take deliberate steps to prevent Mrs. Johnson from becoming aware of her mistake. See, Stephen didn't take deliberate steps, did he? He just sort of let it go. So is there a difference then in arguing unilateral mistake in Maria's case, the little simple case in your study guide, compared to that which was established in Taylor and Johnson? But Taylor and Johnson said that equity could intervene in that case, but generally there are three conditions. The mistake must relate to a fundamental matter of the contract, the other party must know of the mistake, and the other party must take some steps to prevent the mistaken party from learning about the mistake. And have a look at XCB Pty Ltd against Creative Brands. It's a Victorian decision where the Victorian Supreme Court found that the other party's conduct must amount to more than simply failing to correct the other party's mistake, which is arguably the situation with Stephen and Maria. Do you understand what I'm getting? It must amount to something which is unconscionable, an unconscionable effort to prevent the other party from becoming aware of the mistake. All right, well, time's just about up. Thank you very much for your patience in listening to me this evening. Can I ask just generally, quite often I use headsets. Did my voice come through clearly enough that you could follow it? Is it okay? Good. All right. And I could hear you very well as well. So please undertake your reading, enjoy the reading, but importantly, make sure that you read actively. You're looking for those little clues, those little hints that make a difference, and try, if you can, to catalogue it. But you've got a big advantage because you've got the flow charts, so much of the logic of this is already catalogued for you. Just work around that, work on a way that works for you. Okay, we'll call it a night for tonight. We'll see you next week. Thank you very much for enrolling in Contract B, and looking forward to working with you all for the 12 weeks or so. Okay, all the best then. Bye.